Good morning. I'm going to wait a few more moments to make sure everyone's fully connected here. All right, it looks like we have everyone. I will go ahead and get started. Good morning. It is 10:03 on September 11th, 2023. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is what I'll call the first day of phase 3 of the hearing and the court reference proceeding in the case of City of Marina versus RMC Lonestar, Monterey County Superior Court case number 20CV001387. This hearing is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time today you're experiencing technical difficulties or anytime this week trying to communicate with us, please send an email to the AHO at admin@waterboards.ca.gov. AHO staff will be monitoring that inbox and can let me know that you are having technical problems. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Skylar Anderson, Kyle Woldridge, and Regina Graziano with the Office of Research Planning and Performance. I would like to go ahead and move to appearances. I know we've been together Thursday and Friday and now Monday morning, but let's go ahead and formally take appearances. And to do that, I'll identify each of the entities who plan on participating. And if you're representing that entity, please introduce yourself and introduce your or refer to your co-counsel as you see fit. So I'll start with Cal-Am Water Company, please.
I see my colleague's on mute, so I'll jump in until he's not. This is Michael Betts on behalf of Cal-Am. Thank you very much for your time. And just on cue, I think Mr. Moore will introduce himself.
Bob Moore, Allen Mackins, I'm representing Cal-Am. I'm sorry about the mute. I won't do that.
Thank you.
Yeah.
And David Osias, also of Allen Mackins, on behalf of Cal-Am.
Robert Donlin, Ellison Schneider on behalf of Cal-Am. Good morning, Ms. Kinsey.
Thank you. Good morning, gentlemen.
And Ms. Kinsey, I apologize. We have the privilege to have our experts with us as well. Mr. Pete Leffler, Dr. Ye, and I'm looking for Mr. Tim Durbin, but I don't see him.
And our client, Kathy Horning, from the General Counsel's office, is also with us.
Good morning.
Good morning, and thank you for the introductions. I'll turn next to Marina Coast Water District.
Good morning, Ms. Kinsey. Kyle Brochard on behalf of the Marina Coast Water District. Also on the line is Chip Wilkins, Christina Berglund, and Ruth Stoner-Muzine.
Thank you, and good morning. City of Marina.
There we go. Good morning, Skip Spalding, representing the City of Marina, and my colleague Larissa Meisenheimer is joining as well.
Morning.
Thank you. Good morning, Mr. Spalding, and good morning, Ms. Meisenheimer. And then finally on my list, I have RMC. Do we have a representative from RMC with us today?
Yes, good morning, everybody. James Neudecker for RMC Pacific Materials.
Thank you. Good morning, Mr. Neudecker. I apologize. I didn't, you were right. Your tile is right next to mine. Somehow that was too close for me to notice. So thank you for joining us. Is there anyone else on the line who has not either been introduced or had a chance to introduce themselves? All right, thank you very much. I'll pick up where I think we left off at our last pre-hearing conference. We had, just as a matter of background, although we were all there, we held pre-hearing conferences in this proceeding on Thursday, September 7th, which continued then on Friday morning, September 8th. And those were primarily to address a motion for continuance of the hearing filed by Marina Coast Water District and joined by the City of Marina. In the course of those pre-hearing conferences, CalAm decided to withdraw portions of its phase 3 rebuttal evidence that were the bases for Marina Coast motion. And at that time or shortly thereafter, CalAm submitted revised summary slides for its witnesses and revised testimony for its witnesses. Based on the submittals I've seen from Friday, it appears that Marina Coast also submitted revised summary slides based on CalAm's withdrawal of some of its testimony and exhibits. And I'd like to start, I know we have some other evidentiary issues to address, but I'd like to start this morning by just making sure we have clear resolution as to what is in and out and where we are on this withdrawal and the revisions to summary slides and to testimony. So I'd like to turn first. I think it makes sense to turn first to CalAm. I just want to make sure that we have a clear understanding of what the revisions that you submitted. And then I also had a request with respect to the PowerPoint or the presentation slides. I think based on my review, what I understand is that CalAm submitted revisions to exhibits CalAm 183, 184, and 187, as well as revisions to the presentations of two of its witnesses, which are CalAm 190 and 191. But maybe I will turn to one of you. I'm not sure if it's Mr. Betts or however you want to carry this, to just summarize for me whether I have this correct and make sure we're all on the same page.
I'll defer to Mr. Osias other than the comment. We've heard nothing from anybody about what we did withdraw. So, but I'll let Mr. Osias confirm your statement.
Great.
And the short answer is confirmed. Those were the exhibits that were modified. I will complete I think you mentioned 188. I hope you did.
I did not, so I will add
I'm sorry. So 188 is not entirely withdrawn, but there was a listing in the uploading email of 5 model files, among other model files.
Yes.
And those 5 dealt only with the updated recharge sensitivity model runs that are withdrawn. So those were identified. So that'd be one additional comment. And then just logistically, we did not yet submit new slide decks, which we can, but we did identify what the new slides or replacement slides would be, which replacement slides eliminated text referring to the withdrawn topic of the updated recharge sensitivity, and which slides would be replaced and what those replacement slides look like. So we didn't submit substitute exhibits yet. We uploaded exhibits identifying the changes. So for example, the testimony has red line in it. The TM that was modified, that's exhibit 187, has red line in it, so you can see exactly what's being stricken. And then we had a table of what replacement slides were and what they replaced, and we submitted those.
Thank you, Mr. Osias. I think I really appreciate that clarification, and I think I also understood that, and you may have anticipated what my request is going to be, which is at least for purposes of the presentation slide decks, if you would please prepare a revised version, just so that'll be easier for Ms. Mullen when we get to that to just click right through, and we don't have to on our end on the fly try to substitute those in. That would be very much appreciated.
Yeah, we will do that today. Of course, when we did it at 10:30 on Friday, we didn't know whether somebody would say, "Oh, you forgot one" or something.
And I entirely understand, and I understand you were doing that under the clock and trying to work as quickly as possible. So I appreciate the reasoning for that.
Ms. Quincy, it would be very helpful, in addition to the summary slides, if we could get revised versions of the other exhibits that changed as well. You know, for example, exhibit 187, we have the 14 pages that have the red line, but not sort of a revised complete version of it that we can use in this proceeding. So I think it would be helpful to get revised versions of each of the changed exhibits.
I think I agree with that, Ms. Meisenheimer, and so I will turn to you, Mr. Osias, with that request, please.
Yeah,
If we can
I
get
actually understood that.
to
I
apply
understood your
all.
request to be for everything we did.
All right.
Once we've settled on what's to be changed, we will submit new cleans. And I guess the question is, can we call them revised with the same number versus a new number?
I think I will turn to the room if anyone has a different opinion, but I think it makes sense to call them revised and then the same number so that it's very clear what the originating exhibit was, and we have this history of what happened and the basis for the revision. So that makes the most sense to me, but I'll look, is there any reason that anyone would suggest we do it differently? All right. Make it so, please.
Done.
And I did want to say, just for the record, what we're doing on our end with the model files, which I think is part of this larger exhibit 188, what we are attempting to do is to extract from the zip files, extract those files that you identified as being withdrawn and put them in a separate folder on our AHO FTP site within hearing documents and within CalAM's exhibits, but a folder identified withdrawn or something to that extent. So it's very clear that these model files are not being considered for inclusion within the evidentiary record. So we try to keep track of that. It's taking us a minute just because we have to unzip the folders, and the file paths are long and things like this. So, but we are working on that. And all of this is just an attempt, of course, to be very clear about what it is in and out so that later when we turn to this, and this may not be so fresh in our memory, we remember what happened. So we are working on that on our end. I think with that, I'll pause. And before we get to Marina Coast and City of Marina on revisions, I will ask whether there are any concerns about CalAM's submittals of these revised versions of their exhibits and the plan to submit these completely revised versions later today. Are there any other issues about this that we should address now?
We would just ask that, and I'm sure this is the plan in any event, that those be submitted as soon as they are prepared, as I think we may need to update page numbers and things on cross-examination outlines.
Yes, that makes sense. Thank you, Ms. Meisenheimer. So with that, I'll turn to Marina Coast, who also submitted revisions. I saw, I think, second revisions, what I'll call second revisions to PowerPoint presentations, MCWD 175 and 176. And maybe I'll turn to Mr. Brochard, whether if you can describe to me exactly what was submitted there and whether there's anything else we need to know for clarifying purposes about the revisions to those presentations.
Thank you, Ms. Kinsey. As you recall, the parties had requested prior to our request to continue the hearing, the parties had jointly requested to continue the deadline on the summary slides. And the AHO granted that request, but it was after the initial deadline. So we had submitted initial summary slides on the compressed time schedule. We got your continuance, so then we submitted revised slides the following day by the second deadline. And then after CalAM withdrew its portions of the testimony, we then had to revise the slides again to take out our references to that. And because we have a tight time schedule here, we adjusted some of the other slides to and the testimony accordingly. So that's really what we did there. I don't have a table of the slides that were changed though.
Thank you. I understand that. But and just to be very clear, which I think is what you said, these MCWD 175 and 176 are the revised versions of the slide deck, and those are the versions that we should pull up at the appropriate time when your witnesses testify.
Yes.
Thank you. And then I had an additional question, which it looked to me based on the dates in our file folders, which are the dates we moved the files. It may not be when you submitted them. We also have MCWD 177 and 178 that came in, I think on the 8th.
Yes.
And I just wanted some clarification as to what those were,
Yes.
whether those were revised exhibits as well, or what are those?
No, those are not revised exhibits. So in the AHO's July 26th order, which kind of set the phase 3, we were told what to do for phase 3. And then there was a separate order kind of at the end that referenced back to prior phases and figures and tables that had been requested. And Mr. Lilly had said, please provide a chart and let me know if you've already provided this information I'd asked for, please tell me where it is. And if you need to do some additional slides or additional tables, please provide them. So that's what 177 is. That's the response to that last part of the July 26th request. I don't think that has anything to do with the phase 3. I think that was more just to kind of lay out where things were from prior phases.
Thank you. And then
178 is Miss Nelson in her testimony and had referenced confidential data that we had gotten from the Monterey County Water Resource Agency. And then Mr. Betts had sent a letter requesting that data. So we contacted Monterey County Water Resource Agency and were able to get permission to release that data. So that's what that chart is on 178.
okay. Thank you. And then do you happen to know what date you submitted those to the AHO?
I believe those were submitted on Friday.
Okay, great. As I said, I know that based on the file date, I know when we moved them, but I didn't know off the top of my head when we received them. Thank you. Based on that explanation, I'll turn to the room. Are there any questions or follow-up about these additional submittals from Marina Coast?
I'd make one observation, or maybe a couple observations. First, the sequencing of updated 177 and 178, as I heard Mr. Brochard describe it, was not quite right. The withdrawal of the request occurred in the morning. The updated exhibits were filed in the afternoon rather than the other way around. It wasn't, they were submitted and then it was withdrawn. Second, it's difficult to know which exhibits changed. He said they didn't prepare a table. I think each exhibit, the summary slide packet is, I don't know, 50 plus pages. It would have been helpful to have what's changed and to know if it was changed in connection with the withdrawn evidence, which would be perfectly appropriate. I noticed that's what the city of Marina did when they just withdrew 2 summary slides because they addressed the withdrawn material, or whether new information was added, which seems to have been a problem that we struggled with through this entire hearing, of getting new stuff in summary slides. So I didn't hear the answer to those 2 questions. Maybe we could get into a table of what slides were changed so we could compare them and answer whether it dealt with more than the withdrawn information. So that would be my comments.
Thank you, Mr. Osias. Let me start with this. I think it would be helpful. I don't want this to be well, I'd like this to be as straightforward as possible, but it does seem like a fair ask to ask Mr. Brochard if you would please, just in an email, identify the slide numbers that changed as between the first revision of the presentations and the second revision of the presentations. Because of those, I think it seems fairly simple to pull up, and then everyone can pull up the 2 slide decks and just look at the slides. I would appreciate that. And then if there are additional, what I'll say to you, Mr. Osias, since we are starting with CalAm during the hearing, if based on your review, after we get this information from Mr. Brochard, based on your review, you have additional concerns, then we can address those during the hearing.
Thank you.
Thank you. Is there anything else to address with respect to Marina Coast submittals? All right, then I'll turn last to City of Marina. I think City of Marina, I saw that you had submitted Exhibit 67 revised. Do you have anything, if you would please just briefly summarize what that revision entailed? and I will turn to the room to see if there are any concerns.
Sure. We submitted revised to 67. It is the new complete PowerPoint. And the difference between that and the original 67 is that there were 2 slides at the end of Mark Trudell's presentation that addressed the new model that's been withdrawn. And so we eliminated those 2 slides.
Thank you, Ms. Meisenheimer. That's very clear. With that, I'll turn to the room. Are there any questions or concerns about that revised exhibit? Okay, is there anything else we should address about the withdrawal of testimony in rebuttal of phase 3 before we turn to the other evidentiary motions by CalAm? All right, this was very efficient. Thank you, I appreciate that. The way I'd like to set this up, I'd like to move through these one at a time, but just as a little background for us and to make sure that I'm on the same page as to what we're addressing today. I have in my notes here, on September 7th, CalAm submitted, I think what they called a preliminary motion to strike evidence submitted by the city of Marina. The first element of this motion was to strike testimony by, now you're gonna have to tell me how to pronounce this, but Michael Tietze. I'm going to look to
Yes,
correct on pronunciation. Was I close?
Ms. Kenzie, exactly.
Okay, Tietze. All right, got it. And all related exhibits associated with his testimony. The second portion of this motion was to strike Marina 66, which is volume 2 of a document titled Groundwater Sustainability Plan for the Marina GSA area of the 180 400-foot aquifer subbasin for the city of Marina, dated January 2020. And then finally, CalAm moved to strike all testimony related to certain groundwater flow model and solute transport model input and output files that the city did not make available when it submitted its exhibits, although I understand they have now been made available, and we'll get to that. The city of Marina filed a response to CalAm's motion on September 9th, which was timely. I had set a deadline for that. And as I mentioned, I think it makes sense to address each of these separately in turn. So we'd start with the motion to strike the testimony by Michael Tietze. And I think I'd like to turn first to CalAm for just a brief summary of the motion. I've read your papers, I've read the City of Marina's response as well. But a brief summary of the basis, and then I will turn to City of Marina to respond. Marina Coast, you will be invited to respond as well if you would like. And Mr. Newdecker, if at any time you would like to jump in and I don't call on you, please just either jump in or raise your hand. So I'll turn first to you, Mr. Spalding.
Oh, maybe, I'm sorry, did you want to start with CalAm?
Oh, I'm sorry. Yes, I do want to start with CalAm. Thank you.
Thank you very much. I know you've read the motion. We've worked with you long enough right now we see that you've read everything. So we very much appreciate that. I trust you've read the opposition. So I'll limit my response or follow-up to reply, so to speak, to their opposition. And I have 3 or 4 main points. Number, I'm going to start with the law. And predictably, the city cites the government code 11513 that deals with the relaxed standards of evidence and relevance. But really, this has nothing to do with relevance, but rather fairness and the avoiding of surprise, as we point out, which they don't address at all. And the code of regulations, which we cite, actually trump the government code to prevent surprise exactly in situations like this. And indeed, whether the Superior Court or State Water Board hearing, relevant evidence is stricken all the time, if it for other reasons. For example, surprise, exactly what we had here, or sandbag. And if we look at 23 California Code of Regulations, section 648.4a, it tells us exactly what's supposed to happen in proceedings like this, important proceedings, is that the hearing notice can require the identification of experts, documents, and everything of the like. And we had that with Mr. Lilly a long time ago. In March of last year, in May of last year, Mr. Lilly had very specific orders, with rightfully so, very draconian remedies if parties didn't comply with it. The name of experts or the identity of anybody that was going to testify, the production of document files, and somewhat unique to this proceeding, depositions. And in fact, you may not have been involved in them. There was issues that came up of one of our fact witnesses we argued didn't need to be deposed. Lots of motions and screaming from the other side. We had to put up our witness for a deposition. There was an expert that we had, Mr. Leffler. We said he was deposed for 7 hours. The other side said that he didn't. Mr. Lilly eventually found some more time was required for his deposition. Or in fact, Mr. Lilly was going to strike him, a disclosed expert, whose files they had. And we had to put him up for further deposition, for further time. I think it was the day before the hearing and the like. So these rules have been strictly adhered to, and much to our detriment, to the point we almost lost major testimony from experts. And here, there is zero disclosure of this, Mr. Itza. I'm sorry if I got his name right. He got a great first name, but Mr. Itza. And for a witness who they tell us on the very first page of their papers is somebody that's been a long time city consultant experts. Front page that they say that predominantly, but they didn't disclose them until the very end. Zero deposition opportunities, zero documents, zero background files on an issue, quite frankly, the Superior Court has ruled already that the city has no Sigma management rights, which maybe gets to relevant, but that is the ultimate violation of the government code of regulations. So that's my first response to their bringing up the relaxed rules of evidence. The second issue goes to prejudice, and this is the master of the sandbag. To be clear, a timeline is important. They had this information about the variable density model about which they seek to put on testimony since, I think it was June 15th. Since June, over 3 months ago, Mr. Leffler had in his direct testimony information about this model. We then delivered the files. I think it was on August 7th, but there was nothing. We didn't hear any request for a relief, no motion. You've got a quick taste. Anything that time we've done something slightly wrong, whether it's a change in models, there's emails to you asking for relief or parties asking to supplement their evidence. There's absolutely nothing. But rather in surrebuttal or in rebuttal, not surrebuttal, in rebuttal, an entirely new expert, entirely new opinions with no file or no nothing. That is the ultimate of prejudice to us to be able to prepare for that. So to flip it to somehow say they were prejudiced for information they got about 3 months ago, files that they got a long time ago is the cart on the horse or the horse on the cart. It is the ultimate prejudice comes to us. The third point I wish to address again, just in reply, is their reference to the Code of Regulations 648.4b. And this is one that kind of irks me a little bit, is they make a reference as officers of the court to you to say that only deals with direct testimony. And I think this is something that should cause you to cast a cold eye on not only this argument, but their testimony, witness statements, and how things are taken out of context. And they say that that only applies to direct testimony. But if you read the 648.4b, it specifically says that there's a requirement of the identification of the names of each witness when the party intends to call at the hearing, the subject matter of each witness's proposed testimony, and the estimated time required by the testimony to present direct testimony. The only reference to direct testimony there is the time that somebody's going to be testifying about. It doesn't all relate to just direct testimony. That's just an absolute misrepresentation. And if there is any uncertainty in March of 2022, again, Mr. Lilly specifically ordered deadlines for the parties to identify witnesses, documents, everything about which I identified before. So there is no law out there that says that they can come in with an undisclosed rebuttal testimony at the end. It sure doesn't say that in 648.4b. And the reference to that, I don't think was very fair or an honest representation to you. So for the reasons that the California Code of Regulations strongly suggest there should be no surprise, for reasons that we almost weren't able to present experts, for the extraordinary prejudice that we've had, we respectfully submit that his testimony must be stricken.
Thank you, Mr. Betts. I think I'll turn, I suppose what would be appropriate is to turn to the city of Marina first. Would you, I assume you would like to respond to this. As I mentioned, I've read the papers, but you're welcome to respond at this point.
Thank you, Ms. Kenzie. I'll be brief. I really have 2 points to make in response. Number one, Caliam's motion is based on a complete fiction. This tribunal has flexible evidentiary rules. This is not a federal or state court judicial proceeding. Rather, it is governed by the government code And contrary to the representation just made, section 11513 provides very direct direction in this circumstance. And that section has two important provisions. Number one, Marina has a statutory right to rebut the evidence against it. And number two, relevant evidence shall be admitted. Now, Callium mistakenly contends that the May 2022 NOI filings in this proceeding constitute an absolute expert witness designation deadline. They did not, and they were not intended to. Rather, the NOI form directly states that it only covers witnesses who Marina intended to call and who will be providing direct testimony. Well, the fact is, at that time in May 2022, Marina had no intention of calling Mike Tietze. The variable density model was not created by Mr. Leffler until almost a year, actually a little over a year later. And clearly, Marina was not required to disclose Mr. Tietze as a rebuttal witness relating to a model that wasn't going to be created for quite some time. So there is no need for Marina to seek relief from the orders back in May 2022 because Marina had no idea that that model, which is outside the scope of this proceeding, the original scope would be introduced. The second point I want to make is that Callium is posturing here as the injured party. This is ridiculous. Callium created this situation by its uninvited introduction at the 11th hour of this questionable variable density model. And Callium must live with the consequences of the decision it made. If it wanted to bring in this new model, which the AHO did not request and which parties had no idea was coming, they can't turn around and suddenly try to restrict who Marina calls to rebut that model. So Marina has the right to rebut this surprise testimony using its longtime expert, Mr. Leffler on behalf of Callium, Vera Nelson on behalf of MCWD, and Mr. Tietze on behalf of Marina, all served for about 3 years on the SVB GSA technical committees that were involved in developing, commenting on, and working with the model that underlies what the model that Mr. Leffler has provided here. It's only appropriate, and I'm sure that Callium anticipated that Marina would call its expert on this limited issue to come in to provide rebuttal and not direct expert testimony. So from our point of view, it's very important that this motion be denied. The city of Marina has no other expert who can testify to this, and his evidence is undeniably relevant, and it's appropriate here that he be allowed to give it. So thank you.
Thank you, Mr. Spalding. Marina Coast, do you care to add anything to this conversation at this point?
Thank you, Ms. Kinsey. Marina Coast agrees with the city. The notices of intent to appear were filed in May of 2022. The depositions were in October of 2022. The documents that were exchanged prior to the depositions had nothing to do with this model because it didn't exist at the time. So nobody's being prejudiced by Mr. Tietze not being deposed. Mr. Leffler also was not deposed on this issue because it didn't exist at the time.
Thank you.
If I could add one thing, is that this variable density model that's at issue was submitted with the phase 2 testimony, and when Mr. Lilly was in charge, he had CalAm withdraw it and resubmit it because it was surprise evidence, and nobody, then CalAm never gave the city or Marina Coast any information that they were preparing this, as all the parties experts had been working on these other models. And so the irony here is to say that the surprise evidence that CalAm submitted, that Mr. Lilly required them to withdraw and later submit if they wanted to, and we didn't know whether they would or not, didn't allow anyone to designate a new expert. Now, obviously, the city, unlike Marina Coast, didn't have an expert ready to testify. We already had Baron Nelson, who was very familiar with this variable density model issue. So we had an expert. So I just find it ironic and thought it was important to point that out.
Thank you, Mr. Wilkins.
If permitted, I do have a quick response.
Let me turn,
Sorry.
is that Mr. Betts? There you are. Thank you. I also see, Mr. Betts, that Mr. Leffler has a hand up, and I will, although I think this is, well, it's an evidentiary issue. So Mr. Leffler, if you would like to, if you have something to add, and it's okay with your counsel, you're welcome to participate. And then I will turn back to you, Mr. Betts.
Thank you.
Yeah, I just wanted to point out that because it's stated in their response that I misrepresented that Miss Nelson rather than Miss Tietze was the city's expert in my exhibit 178, page 1. But in that exhibit, what I was referring to is that of the 3 experts that are party to this proceeding for Marina and MCWD, Ms. Nelson had received the files at the same time that I had. And so that's what I was pointing out there, because Mr. Tietze was not part of this proceeding. So it didn't make sense to mention him there. So I did not misrepresent what had happened. I was referring to among the 6 experts who had received these files all at the same time. I would also point out that in the roster for this committee, Ms. Nelson is listed as the MCWD representative, as I am for CalAm. And for City of Marina, Steve Carlton is listed as their expert, and Mike Tietze is just listed as an alternate at the bottom. So I just wanted to clarify the record on that point, since I was mentioned in this response. And secondly, I would like to mention that Mr. Lilly in phase 1 in December specifically mentioned variable density modeling because it had been raised by MCWD and Marina experts in this proceeding as something that, has to be considered. And so Mr. Lilly asked for the experts to provide information on variable density modeling, either modeling or analytical calculations. So this effort was in response to a request by the AHO, Mr. Lilly, in phase 1. Thank you.
Thank you. Thank you, Mr. Leffler. And Mr. Betts, I will go ahead and turn back to you.
Thank you for the opportunity. The argument that the notice of intent and all the rules that we've been playing by for the last 2 years only applied to 2 years ago and what parties intended to call 2 years ago makes absolute no sense. That's the ultimate of the prejudice that everyone's trying to prevent. If that's really the rule, then from now until whenever the board rules and then afterwards, we could be submitting new experts, new testimony, new models, new everything. If the rule really is, as they argue now, that we should only be bound by what we intended 2 years ago, that is an offensive argument. The second issue on the authority of what governs here, and I'll go back again to the California Rules of Regulations, which trump, I think, the government code, specifically 648.4E tells us when any of the provisions of this section have not been complied with, the presiding officer may refuse to admit the proposed testimony or the proposed exhibit into evidence and shall refuse to do so when there's a showing of prejudice to any party or to the board. So the argument that there's no authority here and the government control code trumps is absolutely not true. The Code of Regulations tells us otherwise. And the Code of Regulations has very specific rules, which I'm not going to reiterate, that mandate the disclosure of evidence, witnesses, documents, and the like.
Thank you, Mr. Betts.
Thank you.
I think at this point, I am prepared to rule on Calam's motion, at this portion of the motion, and then we will get to the other issues. I think that having a ruling now will clarify things for our continued conversation. I am going to deny Calam's motion to strike the testimony of Michael Tietze. And here's my reasoning here. I think it's well within the discretion of the hearing officer in this position to decide whether or not there is a concern about surprise or prejudice. I know the practice with NOIs, which is very important, is to disclose expert witnesses. And I will just say in my prior proceedings, I know I have not been involved here to date. In my prior proceedings, I have understood those NOIs, at least initially, to refer to direct testimony and witnesses. And then I think what is often a best practice, which was not done here, wasn't done here, and maybe we could have avoided this misunderstanding, is to then have what you might call amended NOIs or follow-up NOIs that then identify rebuttal witnesses, because this is a common problem, right? Where you have direct testimony and then no one really knows who their rebuttal witnesses are going to be until you see that direct testimony. Here we did not have that. Now, in this particular situation, it sounds to me that Mr. Tietze has been involved in the basin for quite some time. So in that respect, this is not an expert outside of, although not involved in this proceeding, this is not an expert who is entirely new to the cast of characters. I'm just recognizing that all of you have been together and working together, or in some way together for quite some time and many years. And to some extent, you're all familiar with one another. I realize that this submission of his rebuttal testimony would be the first time we've heard from Mr. Tietze, and this will be the first time that Calam will have an opportunity to ask him questions and cross-examine him, and that will certainly come into account when I'm considering how much time will be allowed for questioning of Mr. Tietze. So that's an element here where I think there is some room for leeway for Calam to explore maybe more deeply than with respect to other witnesses who have testified extensively in the past in this proceeding. So those are the bases. I don't see a basis for prejudice. Now I'm going to deny the motion without prejudice. If there's something that comes up, we're not yet admitting the testimony into evidence. If there's something that comes up during cross-examination before Mr. Tietze's testimony is admitted into evidence, I would consider a follow-up motion from Calam. If there's additional information that suggests that there's prejudice here, I would be willing to hear that and entertain that. So please keep that in mind as we go forward. Are there any further questions about my ruling on this issue before we proceed to the next issue related to the GSP document? Mr.
So I don't
Osai.
seek to, can I comment real quickly, Mr. Osai?
Please.
I don't seek to re-argue the motion. Naturally, we disagree, but I'm not here to re-argue it. But out of fairness, we would ask the opportunity to depose him and get his file, as with every other expert.
What do you mean by, can you clarify for me, what do you mean get his file?
Sure. So all of our experts had to produce, I think, all documents related to the expert opinions. I'm not sure if we went by California Code of Civil Procedure 2034, but all experts produced all their files related to this phase of the proceedings. And there was some back and forth and debate about that. But whatever rule applied to all the experts, at least as it relates to production of files, we would ask to get that now, like today. And we would ask for the opportunity to depose him before he takes the stand, which was the rule for all the prior experts.
Thank you, Mr. Betts. And then Mr. Osias, I saw a hand from you, so I think it makes sense to turn to you.
Thank
we'll
you. I was going to request, in light of the ruling, a procedural modification. And without re-arguing, I want to just remind you that in direct testimony in June, this variable density model was made a relevant topic. And it was continued to phase 3 in connection with the fact that neither the city nor MCWD had completed their solute transport model and provided any of the scenarios other than one scenario 1A and 1C to either the AHO or to the other side. So since Mr. Lilly determined we needed solute transport to be continued. He continued the variable density as well. So my suggestion is that testimony regarding the variable density model, and by the way, the opposition in rebuttal and other arguments regarding the variable density model did not suggest that new witnesses were needed or would be provided. So there was an opportunity in June and July, which was missed by the other side, to let us know. So I think in light of all of that, it is fair that in the sequence of presentations, so that our experts can hear more versus the couple days they've had, that the city and MCWD go first. And the CalAm gets to go second on this topic.
I have a follow-up question. Why? Why does that make sense? Why does giving, if that's for purposes of, I mean, if your testimony is submitted, I'm just trying to understand and think this through. Why does it provide an additional opportunity for CalAm to present second?
Because through phase 1 and phase 2, both either in the form of expansion or elaboration or in response to questions, be they the hearing officers or cross, the experts who go after that setting learn a great deal more than just from review of the written submittals. And that has proven to be valuable. And we appreciate that in phase 2, Mr. Lilly realized that that was happening and allowed CalAm to go last after hearing what was said by the other side, because they respond to what they heard when they put on their summaries. And so there's not a, I guess, just to repeat with a little bit of different words, there's not a slavish adherence to the written slides or written testimony through the hearing process. More nuanced and additional information is presented, and the expert who gets to go after that and hears it is better able to express their own opinions. That would be my answer to your question.
Thank you. I will, yes, Mr. Spalding, please go ahead.
Yes, thank you. I'll address both of these suggestions quickly. I think MCWD also will want to respond. We strongly oppose the request to depose Mr. Tietze regarding the variable density model. Mr. Leffler has never been deposed relating to this model. Mr. Leffler has never produced documents relating to this model other than his testimony. The depositions and document productions that occurred were back in October of 2022 in relation to the original phase 1 testimony. There has never been any follow-up of any kind in terms of discovery, depositions, or documents for any witnesses. And it would really be prejudicial and unfair in this circumstance to require a City of Marina rebuttal witness to undergo deposition when no other witness, including the proponent of that testimony, will have been deposed. So we shouldn't be prejudiced by a late procedural maneuver that CalAm has done by bringing in the variable density model. The other thing I'd like to say is that it really makes no sense at all to invert the witnesses in the proceeding, as Mr. Osias has proposed. You want to have direct testimony before rebuttal. And I think that the solution that you've come up with, which is to provide flexibility with the rebuttal cross-exam, makes the most sense to keep things moving forward in a logical way.
Thank you, Mr. Spalding. I will turn to either Mr. Brochard or Mr. Wilkins or both as you see fit. Do you care to respond at this point?
Thank you, Ms. Kinsey. Marina Coast agrees with Mr. Spalding completely. None of the experts have been deposed regarding the flow models or the solute transport models or the variable density models or any of the testimony that's at issue in phase 2 or phase 3. It would be odd to have Mr. Titsa deposed when none of the other experts have been deposed on this issue. As for the inversion of the witnesses, I'm not surprised that Mr. Osias would ask that. Callum is asked to invert the witnesses in all of the proceedings, and usually after they've submitted some new model in rebuttal that's caused additional phases to happen, they've asked for sur rebuttal and they've been denied, and the AHO should continue to deny that request.
Mr. Osias or Mr. Moore, would you like a last word on this? Or both of you may have a last word. You can share that.
David, go ahead.
Oh,
If you have the last word.
Thank you. I mean, I just want to remind you that June was a long time ago, and that's when this topic was presented indirect by Mr. Leffler. The fact that he tweaked the model by August 8th is not an excuse for not telling us. And second, I don't have much to add on the inversion other than that Mr. Brochard greatly overstates the history of this matter. And in the last phase 2, Mr. Lilly realized that not letting our witnesses respond to what was said about their testimony by the other side's witnesses was unfair and gave him the last word. Perhaps if you don't want to invert, you'll just recognize that that's appropriate.
I agree with David, and I think in almost every proceeding you're in, when you're receiving testimony for the first time, you haven't heard the person's name. You don't know what they're testifying to. And you have 3 or 4 days or 4 or 5 days, you're entitled to a deposition. So you know what's going on and what his weaknesses are and his strengths as we started this whole proceeding. Or number 2, you get another chance to invert things. I don't know why it's even a question. This is not prejudicial. It certainly is. And that's why we're seeing it for the first time. If they knew it since June, why do they wait until September? There's a reason for that. It's no reason that they're doing some favor for us. It's a reason they're trying to get information before you in a way, the most positive way that benefits them. And that's not what this is all about. It's fairness. And I believe it won't be fair. We'll do it, obviously, if you were us to do it, and you have us on the sidelines and seeing this witness, this expert for the first time when he testifies in phase 3. And I don't think it's much to ask, and we can have a short deposition to find out what he's going to say for the first time. Anyway, that's all I have to say.
Thank you, Mr. Moore. I am going to, at the risk of putting this on, but this is useful. I'm going to just put this out here. I mean, these proceedings work a little, as you know, work a little different than court proceedings. I have always thought of the deposition in administrative proceedings as a useful tool to essentially shorten the hearing process, that it eliminates the need for such extensive time for cross-examination because there's been an opportunity to ask the witness questions in advance. Particularly where a witness is on rebuttal, and we haven't formally at this point set up an opportunity for sur rebuttal, although I'll get to that. That may be a possibility here. I'm not sure what the deposition does that can't be accomplished through cross-examination in this proceeding if there's some leeway in terms of time. But I'm sure you'll have some things to say to me, Mr. Osias and Mr. Moore, about why this is not true. So I wanted to give you a chance to respond to that, in part, educate me on the practicality of what makes a deposition more desirable than having additional time for cross-examination of the witness. I'm looking to you on the fly. I know this is on the fly. What, Mr. Asias, do you have any comments on that?
There is I'll just use an example, and it's probably not the best one because I'm doing this in
Right.
half a minute of preparation. Right?
It's like law school again. So
Yeah, right. So wouldn't it be nice to know that Mr. Tietze was retained in June, had prepared a draft by July, and they sat on it till August 28th. Maybe that isn't nice to know, but I think that would be nice to know because I think it goes to the credibility of the prejudice that's being asserted by the other side. Second, what he was, again, I'll just use this as a hypo because I don't know what he was fed as to how he should respond versus his own independent thinking. Those are the kinds of things you can find out. Okay. Now, those are illustrative and not exhaustive, you know, in any way. But they seem to go to what this crux of this argument is about, which is a lot of timing and surprise. So there's some help there. Obviously, my colleague, Mr. Moore, has taken thousands of depositions where I'm just a lowly water lawyer. So I'll defer a little bit to what else the value of depositions are. But those two examples sort of suggest what would be good to know about what's happening here that we're arguing about right now, that we don't know.
thank you, Mr. Asias, and I will turn to you, Mr. Moore, if you'd like to add.
I'll answer a little bit differently. I have been around this game for a long time. And one of the things that every young lawyer learns early on is that you don't ask a question you don't know the answer to. So the reason why depositions, I think, progress is just for that reason. You can find out what he or she is going to say. And that makes, by the way, it does make the testimony and the cross-examination shorter. Because a lot of what you ask during a deposition, you don't need to ask again. Once you get the answer, that's it. And you focus on the things you think are important. But it's always been said, do not ask a question you don't know the answer to. And it has a variety of different reasons. Well, we are going to be asking questions we don't know the answer to. We've never seen them before. We haven't cross-examined them. And I think that's a fundamental principle. And if you want to make it short, that will make it shorter. If we ask questions that are unimportant given his testimony, we're not going to ask him again. And maybe a lot of his testimony will be just that, things we're not interested in. So I think there is a real benefit of cutting down the time we're using and getting to the point, how we see the point or how they see the point. And I think it's really essential. And I think walking in and starting a cross-examination without really having any background on the individual or anything else is really a disadvantage to us. I mean, and for us to, and I think part of the problem is we'll fumble through a whole lot of questions to get to the core of this. I don't think we'll fumble through it, but I'm saying that as a possibility. But you really are, I mean, we want to know, not just because we want to know for this proceeding, we want to know because we want to know what he had to say and how we would cross-examine him. And I think that's a fair way, and it's been done, you know, it was done in this case early on with experts especially. So that's my thought.
Thank you, Mr. Moore. Mr. Spalding, I do see your hand. Please go ahead.
Yeah, thank you. Very quick response. The two questions posed by Mr. Osias could easily be asked during cross-examination. And in fact, if he gets the answers that he wants, it will be much more dramatic to do it there. We have not been able to depose or cross-examine Mr. Leffler on the variable density model, nor has MCWD. Why should Cal-Am be given an advantage of being able to ask all kinds of questions of our witness about this model when the person who created the model and has put it forth in the last couple of months isn't going to be available for cross? I also have a practical concern. And that is that we have hearings 9 to 5 for the next 4 days. When would we have a deposition? So it's really unnecessary. It would take up a lot of time. And if you were inclined to grant any deposition rights, they should be reciprocal, so that any witness testifying on this subject should be deposed.
If I could respond.
Please, go ahead, Mr. Moore.
We have taken depositions, general depositions, of all the different issues. They now have a witness that because they are isolating one issue, they say we have not had the opportunity to take a deposition. We haven't of that person at all, meaning nothing. And they have taken our depositions of everybody and took a long time doing it and a long time over time cross-examining them during the trial. At one time, it was an hour and a half, I think, with one of the witnesses, our witnesses was cross-examined. To say now it'd be unfair to take his deposition on this one issue when they've taken our witnesses on every issue in a long period of time. I don't get how it was unfair for us now to have a chance to take a deposition of someone we know very little about. We haven't asked him a question. We don't know where he lives, what he does for a living, other than what we'll get from a CV. And sit back and say, well, we got enough, we can just stand up and ask him questions. Well, again, I go back to, you don't begin just by asking open-ended questions of an expert. And if the other side believes that's how you do it, well, maybe they haven't had the same kind of experience I've had in life, but I can't say this more strongly. It's really unfair for us to start asking him questions when he's on the stand for the first time. And it puts us at a terrible, I mean, I don't know what questions not to ask him, which is one of the problems. Of course, you don't want to ask him every single question. You want to ask him questions that may make you or your client look bad. And sometimes that happens. But it's just, to me, is very unfair to be in a situation where they're putting him up at the last minute. They could have put him up 3 months ago. They didn't do it. And again, I go back to what I said before. I don't want to repeat myself, but why not? And so we go back to that, and I really think it's very important. We can make it a shorter deposition. Doesn't have to be 7 hours. Doesn't have to be a long deposition. I mean, 4 or 5 hours would make it, and I'm sure we'd get what we needed in 4 or 5 hours. So we're not asking anything out of the unusual here. We're just asking for fairness. That's all I have. Thanks.
Thank you, Mr. Moore. So here's where I am on the issue of depositions and then the inversion. I don't want to call it inversion, but the ordering of the parties as we proceed into this hearing. First of all, I'm not going to grant a right to depose Mr. Tsietsa. I haven't been convinced that that is necessary to avoid any prejudice. One of the things that has come up in my mind, however, which is that generally in the proceedings I have run, I'm not exactly sure how it's been run previously in this proceeding, but in the proceedings I have run, cross-examination of rebuttal witnesses is typically limited to the subject of rebuttal, and cross-exam about issues outside of that rebuttal testimony has not been allowed when I run these. I think in this case, there's a reason to depart from that general rule because this is a new witness and a new expert. So I will allow Cal-Am to ask questions of Mr. Tsietsa that are more general to his background. So there is a wider scope for cross-examination in the way that a witness presented with a direct testimony could normally be cross-examined in administrative proceedings before the AHO. I think in this case, that's fair, and that will allow Cal-Am some additional leeway to explore Mr. Tsietsa's background and his involvement with these issues. I just, in terms of a deposition, I understand the strategic arguments. I mean, as trained lawyers, of course, you don't want to ask your witness questions you don't, or an opposing witness questions you don't know the answers to. I'm not sure that's the best approach in terms of my perspective, which is to get to the truth of the matter. I mean, I want to run a fair proceeding, but ultimately we are looking to get to the bottom of this. These are experts who are testifying based on their expert opinion and their technical opinions, and Cal-Am will have an opportunity to ask Mr. Tsietsa questions about his background and about his CV. As I've mentioned in cross-examination. I will give additional leeway at this point. I'm not going to give a time limit, but I will give additional leeway to allow additional time to cross-examine him. I think that may make sense as long as that cross-exam is productive here. And then I will also entertain, as I mentioned, I will entertain follow-up motions if there is information that comes out on cross-examination that is surprise, then I will entertain motions about either striking the testimony or whether it is appropriate to allow for some very limited surrebuttal. I do want to get this hearing done, but very limited surrebuttal and how we might structure that. I don't anticipate that surrebuttal would be a situation where we have written submissions. It would be something that would be done orally, we'll see how much time we have left, but that is my vision. If there is surrebuttal, it would be limited. It would be presentation of oral testimony and then opportunity for cross-examination limited to that oral testimony. So I would, once we get through the testimony and hear from the parties, I would be willing to consider those types of motions as we go forward. Essentially, I'd be looking for some kind of, I don't know if the correct term is an offer of proof, but something to justify the need for additional evidence based on something that may come out on cross-examination. I don't want to resequence the proceeding. Once again, I think the potential remedies that I've described would address concerns that CalAm may have. But I understand there are strategic values to going first or second, depending on where you are. And someone has to go first and someone has to go second. So as I said, I will entertain a motion for the opportunity for what I'll call surrebuttal, and we'll see if that's appropriate given what comes out. But I would want some kind of pretty clear justification as to why it's important and helpful in this proceeding to put on additional evidence in response to the other parties' witnesses. At that point, I think I've addressed the issues we've talked about on this, but I want to turn to the room before we leave this. I know it's complicated and very important to the parties. I will look first to Mr. Osias and Mr. Moore, and then Mr. Spalding. I see you're also still off mute, so I will look to you as well. Mr. Osias, did you have anything to add or any questions about this?
Nothing further. I believe I understand what your ruling is.
Thank you. Mr. Moore?
Nothing further. Thank you for listening. I appreciate it.
Thank you. And Mr. Spalding, I see you're off mute. Do you have any questions or seek clarification?
I do not. Thank you.
I'm only picking on you because you're off mute, which I understand you were speaking to me. So with that, I would like to move to the second issue, which is CalAm's motion to strike Marina 66. I think I previously read out a title, but it is, I think, I will just generally refer to it as volume 2 of the GSP, although I understand that there's the whole point is there's some disagreement about what is the valid GSP. But I will turn first to CalAm to briefly describe your motion on this issue.
In the order of motions, I think the first one we felt was the most important in terms of the cumulative prejudice that is now occurring to CalAm. But for this one, I think our papers are clear, is that they seek to admit this groundwater sustainability plan for the Marina GSA. But as we put in there, the courts ruled on this recently. In August, last month, the same court that referred this here denied in a separate action the city's petition for writ of mandate asking that the city be recognized as the purported GSA. The California Department of Water, the County of Salinas, and others also aren't aligned with us and aren't recognizing this. So this seems to be just another bite at getting one more forum or another forum to reject what prior courts, prior organizations, prior entities have already ruled upon. And for those reasons, it's cumulative, it's irrelevant, and should not be considered, in addition to the sandbag issues that we raised earlier.
Thank you, Mr. Betts. I will turn to the city of Marina. Would you like to respond?
Yes, thank you. A quick response. The AHO has already admitted volume 1 of the GSP. It's MCWD Exhibit 44. Volume 1 was the standard suite of topics that are required by the water code in the GSPs. Volume 2 contains comments of CalAm and other parties in which they critique the GSP and contain the responses to those comments. So for, I guess, 3 quick reasons it ought to be admitted. Number one, for completeness, because volume 1 is already in. Volume 2 is a natural follow-on to that. 2, it's clearly relevant here. And 3, it was specifically relied on by this expert. And so it's certainly admissible as a document that he refers to and relies on. So I don't see any point in not allowing it. So we oppose the motion.
Thank you, Mr. Spalding. Marina Coast, would you like to have anything to say about this issue?
Marina Coast agrees with the city.
Thank you. All right, then I will go ahead and rule on this as well, which is I will deny the motion to strike Marina 66. My reasoning here is that this is, I think, a situation where the more relaxed standards of admission of evidence, although we're not at this time admitting the document into evidence, but I'm denying this basis for excluding it from evidence. I think the relaxed standards apply, that this objection from CalAm really goes to the weight of the evidence that should be, the weight that should be afforded this document and statements made in the document, depending on what they're being used for. This is a situation, I think, as the hearing officer, where I can sort through that relative weight given information about whether or not this is the legal GSP for the basin that may have a relationship to how particular statements and within the document are used as evidence. But I'm not going to exclude it on the basis raised by CalAm at this time. Are there any questions about my ruling on that issue? All right, with that, I'd like to turn to the final issue we have, which I would like to talk through carefully. The CalAm moved to strike testimony related to certain groundwater flow model and solute transport model input and output files that the city, as at least as described by CalAm, did not make available when it submitted its exhibits. I understand from the city's response that those files have now been made available, but I do want to understand to the best of my ability what actually the timeline and also the substance of what was exchanged. But I'll turn first to CalAm to describe for me what it is we're talking about here and the timeline of events, if you would, please.
Sure, and I'll lean on some of my colleagues to fill in the gaps here, but there's a concession by the city that they did not give it to us. And the opposition I saw Friday night said is that we didn't really ask them for it. But 2 problems with that. We don't need to ask them for it. Once again, it was ordered in the May 6, Mr. Lilly order, I think the June 1 order. And as with many times throughout this proceeding, and I'm getting to it, this is a cumulative effect, they just don't give it to us. And so and secondly, I don't think we need to ask them for it if it's been ordered. It's like, I don't need to tell them to stop at a red light. If the light's red, the law says you stop, the light's red, you stop. We don't need to tell them you need to stop at the light being red. And furthermore, we did request it multiple times prior to us having to make a motion, and I believe we got it late Friday. This doesn't give us time to prepare for it, to use it in a proper manner next week. If you have further questions on the specific content and the like, I would defer to some of my colleagues.
I do. I think it would be helpful for me, because I'm familiarizing myself, for additional details about what exactly these files are. And
so if I might, I think on the timeline, I think Dr. Ye, who's with us today, and who has been the principal go-between directly with experts on the other side, examines what's been uploaded to the AHO when it's been put into a public file, because we're not given these mostly directly. We download them. Mm-hmm. And then he reviews them, and I'll get him to describe what them is. I understand that's part of your question. But he reviews them and then tries to identify if there's anything missing. And if so, does it matter? And then he generally reaches out. He's had to do this innumerable times since phase 2 started. And so as to the files that we got Friday, maybe working in reverse, he can describe what they are, why he would want to review them, et cetera. I mean, I can tell you that in past proceedings, like say in phase 2, there was a slide that up from the other side that purported to identify something happening. And without looking at the model file, you couldn't determine the time scale for which the something happening would occur. But by looking at the time scale, you could determine that it was infinity. So the model files are useful. And that's just again, a simplistic lawyer's example. So if Dr. Ye is willing, we didn't rehearse this, so I don't know that he's prepared. He's now going to have to take a law school exam as a PhD in modeling. But please describe, Dr. Ye, in your own words, what model files you received late and when you received them and why they would matter to you.
Okay. So the rebuttal phase 3 report was due on August 30th, and lots of modeling run conducted by MCWD and the Marina experts. So on August 30th, I didn't receive any model files. So then I just reviewed the modeling TM, identify the model files I need. So I sent that model file request email on September 1st. Didn't receive any responses. Then I sent a follow-up email on September 4th. Then I received responses from Ms. Vera and Dr. Kincaid. They provide their model files, but I didn't receive the model files from Dr. Trudell. The model file I need from Dr. Trudell is he used KLM's model scenario 1B or 3B. I'm not sure exactly. Then conduct a solid transport model calibration. So he modified KLM's flow model, then run the solid transport model calibration, then claim KLM's model overestimate the ocean water, overestimated the TDS concentration from the test and well. So that's the model files I need to review.
And Dr. Ye, when did you get, you said you got them from Dr. Kincaid and Ms. Nelson. When did you receive those files that you should have gotten on the 30th?
Those are September 5th. Yeah. Then for Dr. Trudell, I received that last Friday, September 8th.
At what time?
Around 5 p.m.
Does that answer your question sufficiently?
Yes, I think so. I mean, to the best of my, I think to the best of my understanding, but certainly the timeline is very clear. Thank you.
Okay.
We may want to circle back. So thank you, Dr. Ye. I appreciate that. I think with that, I would like to, unless you have something else you'd like to add, Mr. Osias, I'd like to turn to the city of Marina to respond with at least their version of events and the timeline.
No, the only other comment is, as I said, this has happened repeatedly. We didn't bring motions until frustration finally set in.
Thank you. I appreciate that, Mr. Osias. I will then turn to the city of Marina.
Thank you. In looking at what's required under the AHO order, it says that parties submitting exhibits based on complex technical analyses also must submit sufficient information so that a qualified independent expert could reproduce the results, right? That's the standard we're trying to make sure we adhere to. And so in the testimony itself, the Marina experts really clearly described sort of what they did, the steps they took so that it could be recreated. I do think that as a practice here, and it's a good one, in general, we have also been exchanging model files because it sort of short circuits and you can fully see what somebody did. There have been some comments about frustrations, but I think there have been requests going in both directions. And frequently after a round of testimony, the experts will send each other emails saying, hey, we need these files, and there'll be fairly sizable lists of files at times. So it's my understanding that in this longer list of files that Dr. Ye requested on September 1st, included certain files from Dr. Trudell. We gathered the files over that weekend, but due to a miscommunication, when the materials that were transmitted from Dr. Kincaid and Miss Nelson went, these files were not among them. And that was a issue on the Marina side, not the MCWD side. And so, but we as attorneys were not aware that that had not gone. And so the first time we learned that those files had not been transmitted along with the files that went on September 5th was when we saw the motion. You know, there was no point saying, hey, I got this, I didn't get this. There wasn't a follow-up there. And so as soon as we learned about it, we immediately got the files together again and provided those over. And I'm not sure if there was a delay, sort of, there's several steps. These are large files often. And so, you know, our experts don't have an easy way of transmitting them. So I know they have to get them to MCWD, and then MCWD gets them over to CalAm is the way they've typically handled it. So from our perspective, again, in the text itself, there was sufficient information to recreate, but we're very willing to provide model files. And as soon as we realized that they had not gone, we sent them over, which should remove any prejudice. This is a fairly discrete issue, and they have had the files for a few days now.
Thank you, Ms. Meisenheimer. Does Marina Coast want to add any additional thoughts?
I'd just like to add a little bit of background as to how these requests have been happening, just so there is no confusion. When there's, and I believe Ms. Meisenheimer is correct, that we provided everything necessary to reproduce the work that we've done, but the experts have then occasionally requested additional files. To be clear, those requests are being made amongst the experts, and the attorneys are not, for the most part, with the exception of Mr. Osias, I think, the attorneys are not on those emails. So myself, Mr. Wilkins, Ms. Meisenheimer, Mr. Spalding, we don't know that those emails are going back and forth and that there have been any requests usually until the additional files have been provided. And then sometimes we'll be CC'd on it, and sometimes we won't. Most of the time we're not. And the experts are just dealing with those issues by themselves. And Mr. Lilly has encouraged the parties to do that, and that's kind of how it's been happening.
I would like to just clarify on this most recent one that Mr. Brochard and I believe and Mr. Osias were on the emails. And that's why and we also made a follow-up request that was not responded to, but I'm not here to brief that right now or argue it. It will come up at the hearing. But we immediately talked to our experts as soon as we saw the email, asked them to put together the files. It's not as simple as you know, just, oh, send these right now. They have to go back and look at the exact file stamps that they're looking for a particular model run or whatever it might be. So it does take a little time, but I do want to make it clear, we immediately contacted our experts, and there obviously was a miscommunication between the city and the MCWD, and I don't think I was aware of it. But I was on this email, so I do this email chain, so I don't want to misrepresent that. And I know I just wanted to clarify that. But we did respond as soon as we were made aware that they were looking for the files.
Thank you. Thank you.
Just
Mr.
to clarify, I don't think anyone from the city was included on these emails, right? So I think there was just a little bit of a disconnect as to how these were going back and forth.
And Mr. Wilkins also wasn't on the initial emails. I'm looking at him.
Thank you.
And Mr. Wilkins couldn't help himself, but the information he wants that he says they didn't get is not a model file.
I'm going to carve out that sounds like a separate issue, and it is not going to affect my consideration of this issue at this time. So I can assure you of that, Mr. Asias. But I'm going to give you a chance, Mr. Asias, and the other CalAm folks a chance to respond. But it sounds to me like there has been a fair amount of effort, which I appreciate, for cooperation among the experts to share files that are helpful in streamlining this process so that we can get these hearing days concluded. And I really appreciate that. It does sound like there was some genuine misunderstanding. Obviously, it would be ideal to share everything on August 30th, and that didn't happen, and the follow-up request perfectly appropriate. And then there may have been some miscommunication that delayed things with respect to a limited issue, a few more days. I do want to make sure there's a fair chance for Dr. Ye and other experts to take a look at what was received on September 8th. I realize we've just had a weekend, and now here we are on Monday morning. We have the rest of the day today, which I'm sure you have other things to prepare for as well, and a busy hearing week. So before I get into any more detail, that's where I'm at right now. Mr. Asias or any other member of the CalAm team, do you want to respond further or make any suggestions about? I would be particularly interested if you have any suggestions for a remedy other than striking the testimony in its entirety. I would welcome that.
So I'll surprise everybody by giving you a non-answer, and it's because I haven't had a chance to see if Dr. Ye or Mr. Leffler or Mr. Durbin have had a sufficient opportunity, having reviewed those files, to see if there's anything that requires a fair amount of work to prepare for the hearings that start tomorrow. If the answer is no, then it's sort of like maybe there's a no harm, no foul. If the answer is yes, then of course you're asking for some remedy, perhaps other than striking, and I need to know more to engage intelligently on that. I don't know that. I mean, it's Monday at now 11:30. But he hasn't been doing it during this hearing. And I'm grateful that he was able to participate, given the other work that they have to do. But I feel compelled to know the answer to my question of has he had a chance to review it, and how much does it matter to this week before I can respond to your question. So I apologize for that.
That seems quite fair to me. So I don't think there's any need to apologize. What I am going to suggest is that we leave this motion outstanding, and I'll give you a chance to see if this is a good idea, but leave it outstanding and address it either. I don't know if it's appropriate to address it first thing in the morning, depending on the time available, or later in the day. Although I suppose if we're all busy at a hearing all day long, it may not matter whether we address it in the morning or later in the day.
So I suspect, I'm sorry, I don't mean to talk over you.
Go ahead. No, please go ahead, Mr. Asias.
There's at least, and I try to simplify things, otherwise I can't comprehend them. So either there's three possibilities. Either what he reviewed will make no real material difference. Okay. And then in which case we'll live with a denial, I guess, of the motion. If it makes a difference, then the question is, does it make a difference to his direct? In which case we should deal with it tomorrow morning. Or does it make a difference to the other side's direct and our cross?
Right.
Right. And so that is sort of an important gatekeeper as to the timing of when we should bring this up again. So again, without knowing that, I don't know whether tomorrow morning is an appropriate thing, or we could actually postpone it even a day or two longer.
Right.
But we'll be able, hopefully, to answer that question tomorrow morning.
Okay.
Because I'm going to confer with them when we get done.
Yeah, if I might be heard.
Please.
Thank you. You know, I want to find a path forward that is sort of reasonable here. And again, CalAm should have had the material that they needed to recreate this since the testimony went in. I understand the model files are useful, but to the extent that there is some information or something in this that they want to respond to, again, all of us are operating on very short timelines on a lot of this stuff. I mean, it may be that they can add a slide if they need to their presentation, but I don't know that it makes a ton of sense to defer this sort of days and days, given that I believe CalAM's witnesses will go on tomorrow.
Thank you, Ms. Meisenheimer. I can understand that as well. I think what I was thinking in terms of is whether or not this issue, if there is some other, depending on the significance of the model files and the importance of having a chance to review those, if a remedy is appropriate, of crafting that remedy. As you know, sometimes as you proceed through the hearing, things become more apparent as to what is important and what isn't important. And I do appreciate avoiding disputes where we can, where these things resolve themselves, especially among all of you. I mean, you certainly have your differences, but you're also have become very adapted at working with one another, which I appreciate. So in thinking about how we proceed next, I am having this idea that maybe we should just revisit this issue in the morning and pick up our conversation there. But I'll turn, Mr. Moore, I see, I think a hand up, and I will turn also to Marina Coast, and if there's further response from the city as well. But Mr. Moore, go ahead.
I did not have my hand up, but I will respond. So
okay.
Thank you very much. I think putting over tomorrow morning, and we can give you a really definitive answer to the questions that David's asking himself as we're going through all this, makes it much more sense. I mean, we may come up with some problems, but I think tomorrow morning will make a great deal more sense than this afternoon, when a lot of people will not be available. And I think if necessary, we can judge what's important, what isn't important tomorrow morning, and address it as it comes up.
Thank you, Mr. Moore. I will turn to either Marina Coast or the city. Do you have any concerns about picking up where we are right now first thing tomorrow morning before we get started with CalAM's direct testimony?
No objections.
Thank you. Mr. Brochard, I think I'll turn to you just as as a representative of Marina Coast. Do you have any concerns about this? I know it's not, maybe not directly, or.
We do not have any concerns.
Okay. Okay. So I think that's what I'd like to do. Let's go ahead and pick this up essentially first thing tomorrow morning before we get into the direct testimony and presentation of evidence by CalAM. And then we will move forward from there. And Mr. Osias will maybe have some of his questions answered, which will help me answer some of my questions.
Thank you.
Thank you. With that, I don't have anything further on my agenda for today, but I wonder if others in the room may have items that we should talk about today in preparation for starting at 9 o'clock tomorrow morning. So I will turn first to CalAM, Mr. Osias, Mr. Moore. Do you have, or Mr. Betts, are there any other issues we should address? All right, hearing none, I will turn then to Marina Coast, Mr. Burchard. Excuse me, or Mr. Wilkins, is there anything else we should address before we break until tomorrow morning?
No.
And then last, I will turn to City of Marina.
Nothing from us, thank you.
Great. And just to go around the room, and because Mr. Newdecker is here, Mr. Newdecker, is there anything else we should address?
Nothing from me, thank you.
Thank you. It's good to hear your voice. Okay, good. Well, I really appreciate the discussion today. I know that these rulings aren't always what you're looking for, but I think we have a clear path forward, and we have a clear path to at least readdress the issues that we're unclear about. So at this point, we will adjourn for today. We will reconvene on this Zoom link tomorrow morning at 9 a.m. We will first address the issues related to these model files where we left off, and then we will proceed with CalAM's witnesses from there. Thank you, and have a wonderful rest of your day.
Thank you.